Good morning everybody. In today's lecture series, we are going to consider about the concept of private trust, how it is different than the public trust, and what is the use of the private trust for the individual or for a family, a joint family or for a business group. How the private trust can be used for the purpose of management of the joint family property or business activities of an individual or a family business. Therefore, we are going to see about the concept of family trust has been gaining more importance nowadays, and many clients are showing interest in the concept of family trust, how the family trust can be prepared and what is the use of that. In order to understand that, first of all, we will appreciate that the property of an individual or a family can be divided by way of one, testamentary succession, that is will, that a person makes a will of his property and the property is bequeathed to his heirs or his relatives or to whomsoever that person wants to bequeath that. But that effect to that will be given after the demise of that particular person, since will comes into effect from the date of demise of that particular person. Second way is that by way of succession, that if there is no testamentary succession, then there are rules of intestamentary succession under Hindu Succession Act, Indian Succession Act, and accordingly the property is divided. Again, that is also after the demise of the person. But what if the person who is a family head, for example, wants to deal with the property or do away with the property, and if he wants to ensure that the property and the business, if at all he is carrying out the business, is properly carried out subsequent to his expiry, subsequent to his demise also, then whether there is any arrangement which can be made by him during his lifetime? Yes, such arrangement can be made by way of a family trust. This family trust comes under Indian Trust Act 1882. This is different than the public trust. Please note that there is a misconception in the mind of many that the trust means a public trust. You go, the property goes to public at large, and therefore there is no, you cannot give it to the beneficiaries or to the certain people who are your relatives to whom you want to give the property. It's not like that. In case of a family trust, also known as a private trust, the trust can be prepared by you, whereby the activities or the management of the assets of that particular individual or whatever is property is put in that particular trust can be looked after by the group of persons known as trustees. This can be done even subsequent to the demise of that person who is the settlor of that trust, who puts in his property in that particular trust, and there will be a group of beneficiaries to whom ultimately the property should go. Therefore, the beneficiary, therefore there are three parts in that, in the private trust or the family trust. One is settlor, the person who wants to settle that particular trust for by virtue of that, who wants to put in his property in that particular trust for the purpose of management of that particular property in the way in which he wants. During his lifetime, he can be a trustee also. In addition to that, he can take any another person or persons as trustee, or he can even employ somebody as a manager trustee, employee trustee of that particular trust and carry out the administration. So if there is a business, family business or a business which has been run, and if the business subsequent to him wants to be run in a specific manner, then in that case, that person can do that by way of putting that particular assets of that business, shares of that business in our company, in the trust, and the management of that particular shares or the business assets will be looked after by trustees who have been appointed by the settlor. Here, a specific prerogative, a full liberty, privilege is there to the settlor of that particular trust, author of that trust, who puts in his property to decide as to who should be the trustee, whether he himself wants to become trustee, whether he wants his wife to become a trustee, he wants his brother to become a trustee, or anybody else should become a trustee in that. Accordingly, once the settlor decides that this will be the board of trustees, the trustees are having a beneficial interest in those assets. They will have only the beneficial interest. They are not the owners. Who will be the owner of that property? The beneficiaries. The persons or the person or persons whom the benefit ultimately should go. Again, this will be decided by the settlor. And for the purpose of deciding all these things, Who should be the trustee, who should be the beneficiary, how the interest will go to the beneficiary, how in what proportion it will go to the beneficiary, that can be decided by the trustee, by the settlor, by virtue of getting the settlement deed or the trust deed for that purpose, which is known as the family trust deed. We will know more about this in the next series. Thank you.